Prime Minister, I'd like to shift gears a bit and ask you some questions about your role as chair of the cabinet. And so it's true, would you agree, that one of your chief responsibilities as Prime Minister is to chair the cabinet?
Yes.
And it's a serious responsibility.
Yes.
And so yesterday, there was a panel testifying from the Prime Minister's office, I'm sure you're aware. And your Chief of Staff, Katie Telford, answered questions about your role as chair of the cabinet. Are you aware of her testimony?
Yes.
Okay. And so she, under cross-examination, she testified that you are the ultimate decision maker for determining the information and documentation shared at cabinet meetings. Do you have any reason to disagree with what she said?
Yeah, that was in a series of questions, linked to, who ultimately decides who's in the room or not. The reality is the authority rests with me. If I, in seeing what the public service has prepared for me as a list of subjects at cabinet or attendees at cabinet or documents to be provided at cabinet, if I have significant issue with any one of them, I can say, no, we're not going to present that to cabinet, and it won't go to cabinet. But as par for the course, I do not spend time going over in advance every possible document going to cabinet to say, yes, this can go, this shouldn't go, this can't go. It's in exceptional circumstances.
So there's advice provided to you by the Privy Council office? Is that what you're saying on what documentation and information goes to cabinet? It's presented to you for review and then you sign off on it, yes or no?
No. For example, if we're dealing in cabinet with a particular MC from, or a particular proposal from a given department, they will put forward that document, that proposal. I will, as par for the course as all cabinet members do, read through that documentation as part of our deliberations that we're about to have. But for me, I have the power to say, no, you know what, we're not going to discuss this today, or this document's not going to go in, which I do from time to time. If we decide, no, it's not ready to go forward, we're not going to do that. But I guess I'm not entirely sure what power you're trying to get me to admit to having or not having.
Sure. So, well, why don't we talk about the February 13th cabinet meeting? The questions are about that. And so you'd agree, sir, that was an extraordinarily important cabinet meeting?
Yes.
A historic meeting, even?
Yes.
And even though it was happening at a time of great pressure, of great urgency, you would have taken care to determine in your capacity as chair of cabinet that cabinet had all the relevant information and documentation before it.
The way cabinet works is we do an awful lot of work in cabinet committees. We do not, as a par for a course, dig into every item that comes forward in a fulsome way because we have subgroups of cabinet that dig into that. So there will have been, before any cabinet meeting, including that one, subgroupings meeting to debate, to discuss things that then get reported back to cabinet.
But you would agree that under the Emergencies Act, as you stated this morning in testimony, the power to declare a public order emergency rests with what you called the cabinet and prime minister, which is the governor
and council.
Right, which is the full cabinet, not a cabinet subcommittee.
No, that's right.
Okay.
Cabinet subcommittees deliberate, but as a matter of generality, they don't make final determinations.
And you agree, there's no way you could have you could have declared a public order emergency without having a full cabinet meeting.
In this case, it was something very important to me. I could imagine catastrophic scenarios in which a government might have to declare a public order emergency without a meeting of full cabinet, either because of urgency or because of circumstance that prevents cabinet from gathering.
So, but in this case, there was such a meeting.
Yes, in this case, I chose to have a meeting.
So I'd like to ask you some questions of what you've termed as the inputs to that meeting. And just to be abundantly clear to my friend from the Attorney General of Canada, I'm not going to ask you about the content of any of those inputs that might be protected by confidence. I just simply want to ask you if certain documents were inputs or not to the cabinet meeting, if I may. So the first is that we've heard in testimony that there was a legal opinion that explained the difference in the definition of threats to the security of Canada in the CCF Act and the Emergencies Act, and you've testified to that this morning. Do you know, sir, if that a legal opinion was provided to the full cabinet at its meeting of February 13th?
In matters of legal opinion, in many situations, most situations, we hear from the Attorney General and Justice Minister who reports to Cabinet on this or that legal opinion.
So was that written opinion provided to the cabinet, sir?
I believe it was a report from, a verbal report from the Minister of Justice.
Okay. I'd like to ask you about another document, which is that we've heard about a threat assessment prepared by CCF, and you're familiar with that as well. And Director Vigneault testified that he'd concluded, or CCF had concluded, that there wasn't a threat to national security under 2C of the CCF Act. He also testified that that threat assessment was provided to the IRG on February 13th. So my question is, was this threat assessment provided to the full cabinet on the evening of February 13th?
In our reporting to Cabinet, there was a reporting on the consensus reached by the IRG, including the director of CCF, who recommended and agreed with the invocation of a public order emergency. We were not at Cabinet dealing with whether or not CCF had the authority to move forward with a wiretap on one person or another. It was a discussion on the invocation of a public order emergency, which requires reasonable grounds for the governor and council to make a determination.
So, sir, you'd agree that that document was not provided to the full cabinet on February 13th? You said a report.
Which document is that?
The CCF threat assessment. And if I could rephrase what you said, you just said the IRG considered that report, it discussed it?
No. Throughout the IRGs, CCF, as a par for the course, would mention that the threshold had not been met for CCF operations within this of a particular type, according to their context and their mandate. But we were not looking as an IRG or a cabinet as to whether or not CCF would be allowed to do this or that thing. We were looking at, certainly by this end, whether or not we had a threshold met for the invocation of a public order emergency.
So Prime Minister, Director Vigneault testified that a written threat assessment was prepared by CCF, and he testified that he provided that to the IRG.
Yes.
Are you saying that that document was not provided to the IRG?
No, that would have been provided to the IRG.
But would you agree that it wasn't provided to the full cabinet?
Yes, I agree that it was, that the report was given, that that the narrow CCF threshold was not met for a CCF operation, but because that was not the issue at play in this cabinet discussion, the issue was the threat of serious violence threshold met in the context of a public order emergency, was the discussion at play.
And Prime Minister, this morning in your testimony, you addressed the policing plan that was prepared by the OPS, and I believe you stated we should read it, we should look at it, because it wasn't much of a plan. Is that fair?
That is my understanding of it.
So, yes. Sir, I'd like to pull the plan up on the screen, please. And Mr. Registrar, it's PB NSC CAN 407734. Thank you, Mr. Registrar. Prime Minister, is this the document or is this the plan you're referring to?
I have not, I have heard about this. I haven't ever actually seen it, so.
So, sir, what I'd like to do, so you've not read this.
No, I have not.
Okay, so
I
I'd
certainly
like,
had not read it on the 13th.
okay. And so I'd like to just, Mr. Registrar, I'd just like to walk the Prime Minister through the pages, not so he could read it because we don't have time, but just to point out that this is a heavily redacted document. So page 1 is the cover page. Page 2 is this signature page. If we could go down, page 3 is a description of the situation and the mission. And then, Mr. Registrar, if you could please scroll down. The rest of this document has been redacted. So that's page 4, page 5, page 6, page 7, page 8. So, Prime Minister, you said we should read this plan. We can't. It's within your legal authority to instruct your counsel to remove these redactions. For the sake of the transparency of this commission, sir, would you consider that request?
I object to that. On behalf of the Government of Canada, it's Brian Gover once again. This is putting the Prime Minister in an odious position. We had no notice that they would attempt this in cross-examination. These things require careful consideration, do not lend themselves to decisions in the moment, and we maintain our objection.
Commissioner, sorry, sir. This was in our document list that we circulated within time to counsel for the Attorney General. They had noticed that we would be putting this document. And the question is a fair one in response to the Prime Minister's testimony this morning that he said you should read it.
I think it is fair in a sense, but I think what's being raised is it's a little more complicated than the federal government or the Prime Minister releasing these. This is a police operational plan of the OPS involving officers from the OPS and from OPP involving strategy, et cetera. And I would be very surprised if the federal government would order its release without consulting with the various police services. And I think that's the unfairness that's being referred to. And quite frankly, I agree. Now, having said that, he made reference to the plan, and there is an issue about reading it for sure, but I think the context is important here.
So, Commissioner, with that, with your ruling there, and I thank Mr. Gover for his point, Prime Minister, can I put it to you this way? You said we should read the plan, but I think you would agree we can't.
Indeed. As I said, I haven't read the plan, but we're in a situation where, as can be imagined, I have access to unredacted information, and what I know and my understanding of this plan was, and I'm happy to testify to that, that it was not a complete plan of engagement.
And Prime Minister, and again, I think I would like to raise this again. I'm looking to Mr. Gover in anticipation of his reaction. As you know, there's a legal opinion that over which solicitor-client privilege has been asserted. We asked Minister Lametti to release that opinion, and in a public statement this week, he said he couldn't because he lacked the authority to. That would be up to his client, and he then clarified that his client is the governor and council. So again, for the record, sir, and this has been an issue for all week, not just this morning, would you advise that that opinion be released in the interest of transparency?
Mr. Commissioner, it's Brian Gover once again for the Government of Canada. Solicitor-client privilege, of course, is a very substantial right in our legal system. It's one that the Supreme Court of Canada has recognized has a constitutional dimension. I remind my friends that in this case, as the Prime Minister has said, cabinet confidence has been waived for the 4th time in 155 years to provide evidence of inputs. We know that the decision note that was referred to in testimony by the Clerk of the Privy Council referred to the advice of the public service that it was appropriate to invoke the Emergencies Act. In my submission, we need not go further with the inquiry and pierce the veil of solicitor-client privilege, setting what in my submission could be a dangerous precedent going forward. And this is certainly an issue that requires careful consideration and not one to require a Prime Minister to respond to in the spur of the moment. Thank you.
Okay, well, I think you have a refusal essentially by council, so I think you're going to have to move on.
Okay, thank you, Commissioner. And so I have one final question, sir. So there has been a lot of discussion this week about legal thresholds and how they differ under the Emergencies Act on your government submission than they do under the CCF Act. And you testified about this morning. I just want to ask you one question. The emergency was revoked on February 23rd, correct?
Yes.
We can take my word for it. And prior to that revocation, there was a great deal of public debate and public discussion about the case for the emergency made by the government. Is that right?
Yes.
And sir, I'd put it to you that not until this commission has the government of Canada ever publicly communicated that the threshold for determining a threat to national security is different under the Emergencies Act than under the CCF Act. Not once. Why is that, sir?
It's in the first line of the public order emergency section of the Emergencies Act that the governor and council can, on reasonable grounds, declare a public order emergency if, in their reasonable opinion, I'm paraphrasing obviously, there are threats to the security of Canada and it is a national emergency. That doesn't mention CCIS threshold anywhere.
Commissioner, I think those conclude my questions. Thank you.
Okay, thank you. Just before I go to the next